Welcome, everybody. We're going to go ahead and get started. I want to first thank everyone for being here. This is a very exciting event. This is the first time the Student Intellectual Property Law Association has hosted an IP conference. And hopefully we'll be doing this every spring for CLE credit, so keep your eyes open next year, and hopefully we'll have another conference for you. So I'm Rebecca Lindhorst. I am the current president of the Student Intellectual Property Law Association. And I would first like to thank our sponsors, CIPLA Women in Tech Law, the Spangenberg Center for Law, Technology, and the Arts, as well as Turley Sondheim Covell and Tamino, and the Graduate Student Council here at Case Western. I'd just like to take a quick minute to thank our speakers for joining us today. We are very lucky to have some absolutely wonderful speakers with us. Ms. Meredith Addy is here from Addy Hart, and she has been recognized as one of the top IP litigators in the country. And for all of our speakers, I feel like I could spend an hour just singing their praises, so I will try to keep this brief. She has been named to the Law Bulletin Publishing Company's 40 Under 40 Hall of Fame. She has also been in leadership positions at several AmLaw 100 firms, and she clerked for the Honorable Paul Michel, the former Chief Judge of the Federal Circuit. And Sue Gerber is not here yet. She should be here shortly. She is at Jones Day right here in Cleveland, and she has significant experience in multiple aspects of patent litigation. And she also clerked on the United States Court of Appeals for the Sixth Circuit. We are lucky to have Michelle Hollebeck and Jeremiah Froof from Stern, Kessler, Goldstein, and Fox. Michelle is a partner in the electronics group, and she specializes in software, digital healthware, bioinformatics, and she's handled hundreds of software and business method applications at the PTO. Jeremiah is a partner in the biotechnology group at Stern Kessler, and he focuses on the structure and function relationships of enzymes, glycogen biosynthesis, and he also counsels domestic and international clients on patent procurement and complex worldwide patent portfolios. And we also are lucky to have Professor Craig Nard speaking. He is the director of the Spangenberg Center here at Case. He is a wonderful professor. He teaches the patent law course and several other courses here at Case, and we are very lucky to have him joining us today for our first talk. So with that, I will turn it over to Professor Nard.
Good morning, everyone. Just a quick recognition of Rebecca, Rocco, and the whole team at CIPLA for putting together a great conference, and Eileen for help organizing it. The sequencing in particular, after this, it just gets better when I'm done. So you'll put me up first, so your expectations will ultimately be met. Rebecca asked me to say a few words about the sort of the history of 101, how we got here. And I'm happy to do that. And you know, as someone who teaches full-time and does a little consulting maybe 10% of the time, I have more of a luxury to sort of reflect on these issues, where when you're sort of in the weeds and practicing and doing really meaningful work like all of you do, perhaps you just don't have time when you're writing those briefs or interviewing examiners to say, you know, what about that IP clause in the Constitution back in 1787? You just don't have that. But I think part of my job today is to situate where we are in eligibility and situate it in our roots, sort of this anchor that we have. Oh, we're not moving. There we go. So Article 1, Section 8, Clause 8. All of you know the IP clause, say IP anachronistically. There it is. And let's just think about this for a second, because I will end where I begin. Right? So if we know this clause to give Congress power to legislate in patents and copyrights, right? And perhaps the most important part of this clause, drafted by Pinckney and Madison, Pinckney of South Carolina and Madison of Virginia, is that preamble to promote the progress of, right? And we know science relates to what today we refer to as the humanities, so we'll just jettison that for this morning and focus on the useful arts. This is the power that Congress has, and that preamble tells us that everything that happens, what courts do and the mess we're in now with eligibility, Congress does really in action, in part by design in the patent space, and the Patent Office, which is doing its best to issue regulations and guidelines only to be ignored by the Federal Circuit as sort of as an administrative law principle. Everything these institutions do has to be anchored in this, right? And we can't lose sight of that. And so when we look at that preamble to promote the progress of, it became clear that even someone like Thomas Jefferson understood that this clause is about adding social value, enhancing social welfare, right? And it's very detailed as constitutional provisions go. Usually we're thinking Congress has the power to tax, necessary and proper, blah, blah, blah. Here, this is a pretty long clause. You have to be an inventor, you have to have a discovery, but the promotion of the progress of the useful arts. So we ask ourselves, today, where eligibility is, where subject matter jurisprudence is it satisfying that provision? Right? And I think most of us will say probably not. You know, unless you're challenging at the moment, and doing an IPR, challenging the validity, you're thinking, oh, of course. But if you're defending, if you're in prep and pros, you're thinking, man, 101 is a hurdle that historically I didn't have to get over, but now I really have to worry about in software, business method, diagnostics in particular, right, is perhaps the most worrisome one. And when we say, is eligibility consistent with that, enhancing social value, that's a loaded term. It's very subjective. You know, we could sort of debate, do we need better can openers and mouse traps? Does that add social value? You know, patent law is agnostic, amoral, non-judgmental. But when we say this diagnostic that really heretofore is now diagnosing something that causes a lot of pain, is a patent that claims that is invalidated, I think we could safely say that when it comes to public health and health generally, that this clause is not being met, is not being satisfied where jurisprudence is today, right? And that's Mayo and its progeny, that's Ellis, and so we have a bit of a mess. So please keep this in mind as we sort of today and moving forward, and ask yourself, everything we do in this space has to satisfy that. Okay. We don't know very much about it. Right, we have one Federalist paper from Madison, Federalist 43, that says, yeah, this is a pretty good clause. That's why we have it. Right, that's pretty much it. But there it is. So from that, Congress wasted little time. Right? We know that in 1790 we have our first Patent Act, which is absolutely tremendous. There's a rich history we drew from Europe, particularly England. In re Comiskey, which is a 2007 Federal Circuit case, said, beginning with the first Patent Act, and this is great language, Congress responded to the bidding of the Constitution by including provisions limiting patentable subject matter. Limiting. So right there, we know that that preamble is not a free-for-all. That there are limitations. You just can't patent anything. Okay? And we'll talk about those common law filters in a second. But that provision in 1790, this is the language that's in that. There were six provisions in the 1790 Act. Six paragraphs. Congress spends more time now. Any useful art, manufacture, engine, machine, I love engine, isn't that great? Device or any improvement therein. That was it. Now look at 1952. Not much really changed. That's 52. Process was substituted for art, and we added composition of matter. That's really, really broad stuff. These are categories. So what that tells me right away is, I'm not sure this is meant to be much of a hurdle. What Congress did based on the Constitution back in 1790, look, the reason I have these juxtaposed is that 1790 is a lot closer to 1787 than 1952. And that 1790 Act and the 52 Act are really close in language. So the 52 Act pretty much reflects what the founders had in mind, Pinckney and Madison. And what did they have in mind? They had in mind a very inclusive statutory provision. Come on in. Unless it's really egregious. Hey, I want to patent gravity. No, we could all agree on that. But you know, if it's close, let it in. And one of the things maybe we'll talk about later, let 102, 103, and 112 do the heavy lifting. Right? This is not a novel concept. This has been proposed before. And I would even say that 101 is sort of the easy way out. You know, doing 102 stuff, that's legwork. That's hard. Finding that prior art, reading it, abstract idea, you're out. No, let it in. That's truer to what the Constitution had in mind, it seems to me. This was drafted by these two gentlemen. We know that guy. That's Giles Rich, the principal architect of the 52 Act. This guy, anyone know who that is? Equally important for the 52 Act. I mean, you know who that is. Judge Michelle had to tell you. PJ Federico. Yes. PJ Federico. The best picture in all patent law literature. He was the chief examiner of the patent office for many years, a dear friend of Judge Rich. Why do I bring these gentlemen up? Because they got it right in 52. Remember what was going on in the 1940s. Very similar to what's going on now. 1940s was led by Douglas and Black on the Supreme Court, a period of anti-patent bias. We said last night that Justice Jackson, the great Justice Jackson, 1950 dissent, said the only patent that remains valid is one this court has not seen. There was one patent after another invalidated, based on the common law powers of the Supreme Court, erecting one hurdle after another, but it wasn't eligibility. The vehicle was the invention requirement, what today we would call non-obviousness. And so based on the great Hotchkiss case, the court would say, you know what, I'm looking at this, there's no invention here. That was it. No invention. That was it. And so it got so bad in the 40s that Giles Rich at the time and PJ Federico and a few others got together with the New York Bar and said, we need to do something. And they drafted what became known as the 52 Act. Why do I raise this? It's because now the question is, this will be the last slide, I will show, not this one, but I'll revisit this. The question today is, we all know something has to be done, but who should do it, right? Should it be Congress? Should it be the courts, agencies? Right? That's something we could debate. Here, it was a congressional response to a perceived and actual anti-patent bias of the 1940s. Section 103 was the driving force of the 52 Act, a direct response to this invention requirement. Vague, malleable requirement. That sounds familiar when you want to apply to 101. So what 103 does, as we know, it demands factual determinations. Now, the ultimate question of obviousness is still subjective. Right? It's the ultimate standard. But it forces district court judges to explain themselves. It forces more analysis and rationale. Things were so bad in the 40s, Congress intervened. Are we there today with 101? Right? That's one question that I think we could talk about. Right? There we go. Okay. To sort of answer the question, and I don't, well, at least lend some clues to it, patent law, we all know Title 35 well. If you read Title 35, as we probably do on a daily basis, very broad general language, full of standards, right? Very little certainty. You know, the grace period of 1 year comes to mind as something that is certain, right? Known or used by others, printed publication. These little words, as my students will tell you, we spend weeks on these words, right? What Title 35 is really an implicit delegation to the courts, right? The courts have the power in patent law, and I think that's by design. Over the past 37 years, we know the Federal Circuit and the Supreme Court have been the dominant drivers. But if you think about it, for 230 years, how many patent statutes have there been? How many revisions? 1790, we just talked about. 1793, which is sort of a wink and a nod because Thomas Jefferson was too busy growing grapes and writing things. He couldn't be an examiner anymore, so they got rid of the examination. 1836, which was a big one, gave us the Patent Office and many more things. 1870, which gave us what today would be our definiteness requirement. 1952, 1999 was sort of a hit and run. And then 2011, with a little tweak here and there. 1994 comes to mind. But really, 2011 was the big one. But 2011, the American Invents Act was even largely procedural. It wasn't substantive. So the 52 is the architect. And so what this tells me is that historically, unlike copyright law, patent law, the drivers, the architects, are judges. 12 of them in particular, and 9 sometimes. Congress and the agency, Patent Office, have their hand in the lattice work of patent law, but it's really the judges, it's really the court. So this question of comparative institutional competence, back to that question, who should address the mess we're in now? Should it be the courts? Are we confident in that? It seems that 9 of them gave us a bit of a mess. Do we really have that much faith? Should the Federal Circuit get involved? Michelle and I were talking this morning, right? Iancu said, well, give it to the courts. It's not rocket science, he said in a recent speech that was reported today. Courts should just step up and do it. What are they doing? They don't have to worry about being elected, right? But maybe it's time. Maybe we're in another 1940, 1952 scenario. Maybe it's time for Congress to engage legislatively in a substantive way, which they really haven't done since 1952. Okay. That takes time, and there are a lot of interest involved. Okay. Let's talk a little bit about the cases. Everything I'm going to tell you, you know. Okay. Donna D Chakraborty, to me, in 1980, really sort of set the tone. Ananda Chakraborty, a researcher at the University of Illinois, came up with this oil-eating bacteria, claimed really 3 different things. The bacteria themselves was sort of the driver here, the controversy. Could bacteria themselves be patented? And of course it wasn't naturally occurring, it was a hybrid. It was living, but it was a hybrid. Okay. 1980 to me reflects a point where the Supreme Court understood that Section 101 was receptive, was wide open. Right? Let's do our battle elsewhere. Let's take a look. There's Ananda Chakraborty and Judge Rich. Judge Rich had this case on appeal when it was the Court of Customs and Patent Appeals, the predecessor to the Federal Circuit. He overruled the Federal Circuit. He was at a conference once about Chakraborty, and everyone was talking about the Supreme Court did this, Chief Justice Berger did that. Judge Rich just had enough. He stood up, he said, look, they didn't do anything I didn't do. Right? But we don't talk about the CCPA, but I recommend that opinion to you. Right? So, Ananda, Dr. Chakraborty's party saying that was a really good opinion there. I really liked it. Okay. 101 says nothing about living matter, right? That's not what Congress does when they legislate. Articles of manufacture, compositions of matter. Congress had 230 years to get specific, like the Europeans, but they didn't. They just let 101 alone. That tells us something, right? Doesn't say anything. Remember the dissent in Chakraborty said, oh, parade of horribles. We needed Congress. Congress didn't say anything. Life is not patentable. And the majority said, look, if Congress wants to intervene and say that bacteria is not eligible for patentability, they could, but they didn't. Right? Things are okay. So 101 says nothing about living matter. Sorry, this is not the... So here's just some language, just to show you what has happened from 1980 to today. This is the Supreme Court. Just take a look at some of this language. In choosing such words as manufacture, composition of matter, we're talking about 101, right? The majority said Congress plainly contemplated that the patent laws would be given wide scope. You would never see that today. Right? What else? I'm just going to have to resort to this. There we go. Going to the legislative history, even citing Jefferson, who was no big fan of patents. The act embodied by Jefferson's philosophy that ingenuity should receive liberal encouragement. That's plugged right into the preamble of the Constitution. Okay. Court is setting the stage for a wide open 101. The committee, this is the famous, perhaps the most famous cropped quote in Supreme Court patent jurisprudence. Anything under the sun made by man. Okay. This is where the court is. This is the court at this point in 1980 is saying 101 welcomes pretty much anything. Anything that, when we talk about life, remember the court said, hey, the fact that this is living is of little moment. Doesn't matter. Life is patentable. That was extraordinary in 1980. Right? As long as what results has markedly different characteristics than that which occurs in nature and has some utility. Right? That was quite significant. Now the court, with that holding, Chakraborty is largely credited with launching the biotech industry or giving it extraordinary impetus, along with the Bayh-Dole Act, allowing universities and nonprofits to own patents on federally funded research. Remember, this was right after Cohn and Boyer and recombinant DNA, Stanford. Things were humming. The majority knew there was this burgeoning industry out there. Okay. If you read the opinion again and again, you'll know it's kind of circuitous. There was a really powerful dissent, but the court wanted to get where they ultimately got. They did say not everything is patentable. We have certain common law filters, and we know them. These now, particularly laws of nature and abstract ideas, Mayo and Ellis respectively, this is the tool. These are the tools of the Supreme Court now, much like the invention requirement was in the 1940s. Chakraborty said, these are off limits. Okay? There is a limiting principle to promote the progress of the useful arts. We're not going to let everything in. The so-called exclusionary principle that we see at play in Ellis and Mayo, right? We know the arguments here. If you patent gravity, if you patent mathematical formula, the scope of that is extraordinary. I would say this, and I'm not going to dwell on this. I don't know of any subject matter that is rejected under 101 that cannot be handled under 102, 103, or 112. I don't know. It's just more efficient. But we have these filters. Okay? More on that in a little bit, and of course, law of nature and abstract idea form a big part of what's going on. Nonetheless, even though Chakraborty cited those filters, and there are cases where there are certain types of subject matter that got caught up in the filter, as early as 2010 in Bilski, the court said, wait a second, we're not going to have categorical exclusions for business methods, for instance. We're tempted, but we're not going to do it. Remember, Justice Stevens really wanted that. But no, Kennedy said we're not going to do it. Why? Because times change. Times change. Technology and other innovations progress in unexpected ways. Love that. This is why Title 35 is so broad and welcoming. The language of the code can handle anything. The key is who fills in those interstices of the code. Congress, courts, etc., agencies. That's the key. We want a code that welcomes everything. This is why non-obviousness could address any type of technology. This is why 101 is so broad. So 2010, we're still okay, it seems to me. Now, something happened. Right? Something happened. Remember State Street Bank and AT&T in the late 90s? Right? Judge Rich, concrete, useful, tangible. He was criticized for that opinion quite a bit. But he was a hawk when it came to novelty and non-obviousness. His view of 101, as we've already demonstrated, so I think is the view of the founders, is let it in. Let it in. Let's see if there's really something special here. I have no problem with 102 and 103 aggressively policing the public domain. If it's been around, no way we're letting you in. But why? It's like summary judgment or motion to dismiss. What are you afraid of? Come on in. Let's examine it. So you had those cases, and then a decade goes by, and there was this sense that things were a little out of control. Now, I think that's a false sense. Again, if it is true, it's more a failing of aggressively applying 102 and 103 and maybe 112. It's more that than it is any interpretation of 101. You know, people treat 101, and my colleagues who teach view 101 maybe a little bit differently, but there are folks who would echo this too. They treat 101 that, okay, if we say you're allowed, you fit into 101, all of a sudden you're patentable. We make that mistake. We say, no, you have a whole sequence of things to go through. Hold on. We're just saying, come on in. We may not like you at the end, but we're going to take a look. And so this notion that 101 sort of, you let it in, like State Street did and others did, the patent system's broken, I think is so misguided. Even though even the Onion sort of played around in this space. So we're in this era of patent skepticism right now. It's 1940s redux. It's all over again. And we all know that there have been cases we'll hear about today, and I'll say a few things. The pendulum perhaps has begun to swing back a bit. And there's nothing wrong with having a pro-patent, more skeptical court or Congress go back and forth over the years. But the shift, when things are so askew on one side, there has to be some type of action, because industries are definitely affected. And I'll cite a few studies that actually show that software, and in particular medical diagnostics, are taking a hit. Those of you who toil in that space know better than I. Okay, Mayo. Again, we're going to hear a lot about Mayo, so I'll just say a few things about it. We know what's going on with Mayo. Thiopurine drugs are administered. Metabolites that happen in the body when thiopurine drugs are ingested, that's well known, right? What wasn't known is sort of this correlation that if the levels of the metabolites are too high, there could be harmful effects from thiopurine. If they're too low, the efficacy of the drug is called into question. And so the patent says, hey, we could sort of measure that and adjust, determine, administer, right, the famous germs right now. Okay? This was an insight. Okay? And so the Supreme Court looked at this is 2012 and said, you know what? This is a problem. This is really a law of nature, right? Measuring that correlation. Remember, the Federal Circuit said, there's a sort of a transformation that goes on when those drugs are administered. And this is sort of applying Bilski back in the day. But this is a law of nature measuring this correlation. And therefore, you know what? There's nothing wrong with that. We're not going to end it there, but now we need to have an inventive concept. Boy, that sounded so much like importing 103, which makes the point again, hey, what are you guys doing? You're sort of in the sandbox of 101, but you're inviting other friends, 102, 103, come in here and help us out, because we don't know what the heck 101's about. It would be so easy simply to say, come on in, 101 satisfied, next. Right? There's an innovation here. And let's add some certainty. We're comfortable with prior art and publications. So this notion of an inventive concept sufficient to ensure that the patent in practice amounts to more, I have no idea what that means. Right? So the additional steps recited, here's that language, right? Here's that language, and Ellis echoes this, consist of well-understood routine conventional activity. And when Sue gets here, she'll tell us about, this is now a factual inquiry, right, from Burkheim. So now we sort of get past summary judgment. And so that's helpful. But still, you have this. What does that mean, well understood routine conventional? Does that mean that it's not obvious? Why not just apply Graham and KSR and the progeny there and have at it? We're doing it at 101. And then he applied it to deer, because this is what we're left with, right? Because we don't know what abstract idea and law of nature are sometimes, we have to rely on precedent. That's fine. So you looked at deer, the Arrhenius equation. That's not what's being patented here. How's this different than deer? Well, none of the additional steps of deer claimed eventually were in context obvious. Right? Stay in your lane, already in use or purely conventional. Okay? So this is 101. Right? That's what Sue, I just brought you up. I was talking about Berkheimer, how unless this is now factual inquiry, right? And so that's helpful. The pendulum maybe has begun to swing, as we said, but that's Mayo. So we sort of have this, okay, we got a natural law, this correlation, and then we need an inventive concept. Now we have to talk about routine, well-recognized, all these things. What are we doing here? We're just making this really, really messy, okay? And here comes Ellis. Now, Ellis to me is almost comical, right? Michelle, you mess with Ellis all the time, right? I can't wait to hear what you have to say about Ellis, because I know I'll learn something, because I don't know anything. Right? I look at this, so we know what's going on. It's settlement risk, okay, exchange. This is an abstract idea. Okay, great. What's an abstract idea? We don't need to really say. We don't need to define it, right? Thomas said, we need not labor to delimit. Not even trying. We need not labor to delimit the precise contours of the abstract ideas category. That filter, right? That filter. So we got law of nature in Mayo. Now we have abstract idea. And I can't tell you, I mean, sometimes judges could be really candid. You'll see cases where we don't know what this is. We don't know what an abstract idea is. It is sort of Potter Stewart, right, on pornography. Know it when I see it type of thing. What does that mean? So, of course, they brought up Bilski. We just know this looks a lot like Bilski. Right? Therefore, it's an abstract idea. That is not a jurisprudence. That is not to promote the progress of the useful arts by saying this is an abstract idea, but we don't know what it is. That's so bizarre to me. Right? That's murder. I don't know what murder is. What is murder? That's no way to run criminal justice. So we have this two-step that we're all very familiar with. Is the claimed invention caught up in one of the filters? Okay, and again, I'm not against the filters, but for me, it has to be blatant. Again, I keep coming back to gravity because that's the most obvious thing. You can't do it. Okay, I get that. If it's in one of those filters, there it is. We're here. Okay, additional element. Is there something more? As we ask. Is there something more? Dear, there was something more, sort of retroactively. And this is the test. What do we do with that? Okay, that seems really messy. So this is the famous two-step. That's where we are today. Okay. Again, that strikes me as overly convoluted. The court gives some explanation as to why we have a robust 101. Again, they call it the exclusionary principle because if we patent things like gravity and E equals mc squared, then the scope is extraordinary. Well, if the scope is extraordinary, that's 112, it seems to me. Right? That's novel. We're lacking in novelty, it seems to me. Right? So I understand why you don't want to give protection to laws of nature or abstract ideas, but again, I just don't know if 101 is the best way to do it. Okay, the progeny. I'll just say a few things here because I know I'm getting on the turf of our excellent speakers that are going to follow me. Athena, which followed Vanda. So here Athena is a really interesting case. This is 2019. A phenomenal, it seemed to me a great insight, this particular invention. The diagnosis of mesanthia gravis, which is this really bad muscle disorder. These antibodies show up in this particular disease in 80% of the patients, certain antibodies. And we know them. But it was really the 20% that we didn't know. And here comes our patentee saying, you know what? We can identify those 20%. We have a way of doing it. Okay? We know how we could do that. And it says, these antibodies that attack a specific protein. So these 20% that are outliers, that we're suffering, don't know what they have. Now we have a way of detecting this to promote the progress of the useful arts. So Athena invented this method of recognizing antibodies. Now this, you read Mayo, you're thinking, man, they're in trouble, right? And you read the claims, same thing. And the court said, essentially, this correlation is just like Mayo, right? This is a law of nature, how the body reacts, and nothing more, right? And what seems like a tremendous insight, Ariosa comes to mind as well, the court invalidates and says this, because remember, Vanda was right there too. Vanda was just before that. The court makes this distinction between sort of recognizing this law of nature, this correlation, and a method of treating it by administering a drug. And the Patent Office issued these Vanda guidelines as a result. Claiming a natural cause of an ailment and a well-known means of observing it is not patentable. But claiming a new treatment for an ailment, albeit using a natural law, is not claiming the natural law. So method of treatment. So do you draft method of treatment claims now? That's really interesting. But again, another case where diagnostics takes a hit. On the IT side, the Ellis or abstract ideas side, there's Berkheimer, which said this routine, well-recognized inquiry in step 2 of Ellis. That's now in the context of summary judgment. We need some fact-finding here. We need to answer some factual questions here, and so at least gives you the opportunity to get to trial, to make your case. You're not going to be tossed. So more attorney's fees on the party challenging the patent. And then Atrex software is another one in the context of a motion to dismiss. Again, judge expressing discomfort with making this determination so early on in the process. Okay? So we have, again, just this pendulum. Vanda, there's Atrex, there's Berkheimer, DDR. I mean, you have these cases, but it's not sort of the systematic march away from where we are right now. Now, whether that's because the Federal Circuit is reticent to take on the Supreme Court head on and say, look, if you're not going to grant cert on some of these issues, like Ariosa would have been perfect. If you're not going to grant cert, then we're going to do this. In fact, hasn't the Supreme Court says time and again, we're going to leave it up to the Federal Circuit and their common law powers to sort of fill this out. And when the Federal Circuit does, sometimes the Supreme Court intervenes and say you got it wrong and just create more of a mess. So there's a certain reticence at the court. Now, the results are real. Colleen Chen is a professor at Santa Clara, does great work. She looked at the software and medical diagnostic industries. And Colleen has been critical of being, I wouldn't characterize her as necessarily pro-patent, but she's very capable and her work is so good. This is an empirical study she did of the industry, and she uses these words, that the medical diagnostic industry, Ellis and Mayo have resulted in an acute and discernible increase of 101 rejections, and they're taking a hit. Now, those of you in medical diagnostics, Jeremiah, you may see this. There's real concern, is my understanding. And again, because of that, are we going to have fewer dollars, less research and development, fewer innovations? Again, moving away from Article 1, Section 8, Clause 8, it seems to me. Berkeley did a study a couple years ago looking at the industries. They did medical diagnostic and biotech, which is really worried. They look at the number of patent applications filed, money spent, general sort of concern within research groups, chief technology officers. It's real. The effect is real. Okay? And there's money there. There's public health there. These studies are, I think, tell an important story. What to do? Well, it seems to me, this is a quote from Judge Laurie, and this is his opinion on the denial for a petition rehearing in bank. He says, I believe the law needs clarification by higher authority, perhaps by Congress, to work its way out of what so many in the innovation field consider a Section 101 problem. That's a nice understatement. But he gets it right. Judge Laurie's always very reserved, right? PhD in chemistry, right? Very smart. So the question for us is, and this is my last slide here, the question for us is, okay, what do? We know there's a problem. And we'll frame it like I framed it at the beginning. Is it time for Congress to intervene? The courts. I think those are our two options. And so we have to think about the comparative institutional advantages. Patent law, again, the courts have been the drivers by design, but they seem to be stuck in mud. There's this inertia. You do it. No, you do it. I'm waiting for you. The Federal Circuit can do it. As our commissioner recently said it, just address it. Go en banc, address it. Right? And take your hit up above if you have to. But you could do it. The alternative I'm fearful of, if you go back to Congress, because in 1952 was different than it is today. Right? The 52 Act was really drafted by 4 people. That's it. Judge Rich had note cards in his chambers. That was the legislative history that they do. They would draft a provision. They would send it around the country to patent law societies, Seattle, etc. And they would, and the patent law group in that particular city would draft comments, send it back, and that's how they did it. Today, as quaint as that is, right? Today, I can't imagine what Congress would come up with. Right? There are a lot of proposals out there. But the more sort of detailed we get, I worry about getting too detailed, because if there's a mistake in Congress, you know how long it'll be before they get to revisit that? So to me, leave 101 alone. Courts, 12 people, Madison Place, I think you could do this. I think it's time you could do this. You have the tools to do it. I'm done. Thank you very much. I'll take some questions if you want to talk about it. If not, I don't want to hold you back from what's going to be awesome. As I told you, it just gets better from here. So I'm happy to entertain any questions you may have. Comments, too. I welcome comments, pushback. Yeah.
Have you tried to see if the cases line up better if you do the 102, 103 analysis first, and then?
That is such a good question. I haven't, but that may be my next paper. No, but actually, it's a good idea. My sense is that if you reject it as a law of nature at 101, then 102 becomes pretty easy. Right? It's like, if Mother Nature is the prior art creator, 102 is like that's. But so my sense is that I'd be more interested if there are cases where 101 bans it and 102 for some reason does not. That would be really interesting. Right?
Yeah, but I don't know why you would look for that outline. I mean, I think the thing is more like you can have a diagnostic method where you do exactly the same test as was done in the past, and that until you look at the invention, you don't know that it's the interpretation at the final stages.
Yeah.
So the only difference is that now we're going to interpret it a new way according to the principle, and I think that's where the court seems to have a problem with a claim that might be passable with the test learning. But in this particular case, because what they're really talking about is what you do with the resulting data, and there's no subsequent step to apply treatment.
Yes.
I think that's what they're worried about.
No, I think that's a very valid point. And I think what you're suggesting is that if you get into 102, 103, all sorts of other policy levers come into play. Right? You sort of can interpret the language or the claim language in a way with sort of what patent law is meant to achieve more, and then you could have maybe it gives you more room to roam or justify why you would allow something in, it seems to me. That's a great point. Thank you for that. Yeah.
So playing off of that point, two things, and we can discuss them further as the day goes on. One is, at least in the software industry, you can find these cases where the PTAB said, this passes 102, this passes 103, and then later it goes up from the federal circuit to the federal circuit on 101 and fails. And I find those to be offensive. They're offensive. So that's one. I know that about a year ago when I looked at this, there were maybe 5 of these cases. There are probably more. And there's a statement by Judge Chen, because I had one of these cases, so I did this research. There's a statement by Judge Chen where he says just because it passes 102 doesn't mean it's going to pass 101. But he doesn't really support it. So there's that. The other seed that I'll plant for discussion, because I'm scared of Congress too, and I believe the Federal Circuit can fix it if they would just get their head out of the mud. But Judge Michel thinks it's too far gone for the Federal Circuit to fix it, and we're all scared of the Supreme Court. So one proposal, the best proposal I think I've heard, is to just change the number of 101 and make it maybe what is 117? Something that comes after 102, 103, 112, it's 117. And the only change is to make this will be performed after. So that's just, that way you keep everything you want, but you can't trust Congress to get that done.
Yeah, no, that's really interesting. This whole notion of, that's bizarre. What do you think about that? It's like you allow it in 102, 103, but it gets filtered out in 101. Is that right here?
They're doing already. I think when
you think they're peaking at 102, 103?
Well, I think earlier when you read the cases, they're talking about, that's why it's so confusing. They're saying, what are the differences?
Yeah.
And they're trying to apply the 101 analysis to the differences. Like in 103, you have to determine what is.
And so they import that analysis anyway in 101 is what you're saying.
I think that it's happening here.
Yeah.
I think that's one of the reasons. Of course, I'm not going to pretend that I can line up all of these cases.
No, but your question was excellent. And Mimi's point about that, it just sort of highlights the fact that it looks like maybe there's more to 101 than just 102 and 103. Because we're saying, look at this inventive concept, this stuff. It looks like you're just doing a 103 analysis in the context of 101, therefore make it 117. But it seems that if you get trapped by 101 after you make it through 102 and 103, what else is going on that we could wrap our minds around with any certainty? Sue.
And I'd like to put the additional layer on here that we never get to 102 and 103 in the courts because so many of these cases are getting poured out on the pleadings with no factual development, no record. This is the Berkheimer problem. And so I think, to Merida's point is, get past, do the analysis, let the record get developed. And if you still think there's a problem with eligibility, fine, consider it there on a full record.
But flush that out.
Exactly.
Flush that out, yeah. And I think that's what 103 and Graham did in the context of the invention requirement. Just it smoked that out, any bias out, forced you to explain yourself. Hey, Rick.
Great. So the Bannon decision has helped us move
No
the
doubt.
pendulum back a little bit, but it's on petition for cert. So do you have a thought on whether or not that's going to get granted?
I have a mixed view on that. Like maybe I'm thinking, boy, I hope not. Because we said last night, and just to be fair, I thought Festo was the last really, really good opinion. What do you agree with that? I mean, every sentence is meaningful and dense. It's so good, right? But it's a long time. It's been a long. Because I wasn't even here at the time. Yeah. There you go. So I might have a mixed view. My preference would be for the Supreme Court to assume the role of the 1980s, when there's a tremendous outlier. The Federal Circuit's still young, right? And you have good people up there. I just don't know if there's a lack of political consensus when they meet, or what, to take something on and address it head on. I would hope. Right now, I would say I hope they don't, because I don't know if it's the best vehicle necessarily. But boy, I know I would file for petition too, armed with Mayo. Yeah. Anybody else? Thanks, gang. Appreciate it. Oh, sorry, you had something?
I was going to ask, there's a mere printed matter that's never really been patentable. You agree with that?
Yeah.
So isn't software code,
Oh, that's interesting. Yeah. Right.
matter, it's just saved electronically?
Right.
Could they go there and just say, as this category, it's printed matter. It's saved in electronic form, but it's printed matter. You can't have patent.
Yeah, I assume you could. Now that's a bit out of my wheelhouse. Michelle?
Yeah, I mean, we've looked into that a bit, and when you have software code, if you are really trying to patent the code, that implementation, that would certainly fall under printed matter. But remember, the patent system is supposed to be for the idea, not necessarily the implementation, right? And so part of the idea with, yes, it is something that is done digitally, does that make it implemented in a particular code? You could go to the pseudocode level, right? What language is this ultimately written in? How is it stored? But really, when you're looking at, say, a computer-readable medium claim, it is the way that they're written now, it's claimed in the sense that when it's executed, it performs a process, right? Because it's still that process, it's that idea. You're not claiming the code itself. You're not claiming the implementation, which might be something under copyright, but you're really trying to claim the idea, what it is doing, what is the underlying method, that then you have various ways of implementing that.
That sort of explains that pivot from copyright patent decades ago. That's the reason, right? But copyright law was too cabining. I like that question. Mimi, do you have a follow-up?
I was going to say the same thing. I think it's been about 30 years now, but when people didn't understand software very well, and there was this thought that it's just like a book. And so there was this tension between copyright and patent. And I remember reading about, well, it's just a book, which would be like the same thing. So I think they got past that. At some point, somebody did.
That's right. Okay, thanks.
want to, to my right.
I was going to come up with nothing, but you had a record, so I thought I had to look like I knew what I was doing.
I'm sure Rebecca's trying to get name tags. There they are. That's okay.
We have this extra chair. Big video, right?
Yeah.
Another chair. So that we look good.
Okay, so we will be starting our first panel discussion here. To my right, you have Miss Meredith Addy and Sue Gerber. I think Rebecca already said a lot about them, but if you would like to just reintroduce yourselves and talk a little bit about what you do and what your practice is.
Good morning. I'm Meredith Addy. I go by Mimi, but only to co-counsel, not opposing counsel. I am a litigator. I have probably most of my experience at the Federal Circuit, and recently left big law practice and opened my own little boutique. We do litigation, we do Federal Circuit appeals, and my partner, Mr. Hart, he comes from in-house and he comes from a prosecution background. So I'm enjoying this because we're able to kind of combine both the prosecution side of things and the litigation side. When you get a client that can actually think that far in advance about what they want to do with their IP. So that's who I am. Thank you.
So I'm Sue Gerber. I am a counsel at Jones Day. I've been with Jones Day, it'll be 31 years this fall. I spent several years before I went to law school. I was staff at Jones Day, and then after I graduated, then I went back. I also took a year to clerk for the Sixth Circuit Court of Appeals. And my practice is all litigation. I do patent litigation predominantly at the District Court and the Court of Appeals, and also have a little niche practice in international discovery under Section 1782. So.
Okay, well, I think we should just jump right in. I think maybe we should have just opened it up to everyone to begin with, but how about you just get us started and see what the landscape is.
So we have slides, but I think a lot of them are background, and we don't need to cover them. We can, we went over earlier that how different these exceptions are from the statute, and maybe if you could pull that up. That, I believe, is slide 5. There we go. It's incredible to me to see this. I don't know how many words they even have in common, if any, other than the.
Yeah, I would agree. I think it's sort of this artificial construct that's been laid over top of the statute, and I think when we had this turning point with Alice and Mayo, that it's just created such a tremendous amount of ambiguity and uncertainty in the law, and I feel like the courts have really struggled with what to do with. They feel like they're obligated to deal with 101. They feel like they have to deal with it on the pleadings, and so this is an issue that they deal with they're ill-equipped. They have no good precedent to rely on, and they often don't have any facts to rely on, and so the courts, I think, are really struggling with trying to deal with the Section 101 in a post-Mayo and Alice world.
And if you really wonder how bad the damage has been, the district courts have addressed over 1,500 patents, and of those, they have about a 60 under 101. Let me clarify. And of those, they have about a 60% invalidity rate. So you still, even 4 years after Alice, you have a really good chance if you're a defendant and you want to file an Alice motion. What I thought was really telling as well, and this speaks more towards the anti-patent sentiment in the U.S., but even if you survive a 101 at the district court on, one of these cases and you don't settle, you still only have a 25% chance of winning if you're the patentee. And I wonder, what about the presumption of validity? What about all these other safeguards that are built in the statute? They've all kind of gone by the wayside.
Yeah, I agree. And it's a really inequitable situation because the safeguards are still there in 102, 103, and some of these other sections under the patent code. But 101, it's like all the historical rules and safeguards, they get thrown out the window. And I think, to Meredith's point about it, the Federal Circuit, and a huge percentage of the district court affirmances are actually done on a Rule 36 affirmance, where all you get is a one-line order that says, we affirm. And no rationale, no direction, no anything.
So I have some slides on this. And I had so many cases going up from the Federal Circuit to the Supreme Court on cert petitions. And I will say, I get hired sometimes after the Federal Circuit decision. There's not that much I can do. But in doing these cert petitions last year, I did these statistics. And these are the Federal Circuit statistics. So if you come up on appeal as a patentee after losing a 101, you got about a 10% chance of getting that thing reversed. And you can't tell that these statistics are so bad because 50% of the cases are decided by Rule 36. And you can't tell that getting these stats is really difficult. So in order to get these stats, because when you see a Rule 36 decision, it just says affirmed. And you don't know how, you don't know if it was a 101 case, so how do you track that? And I started tracking all of the district court decisions on 101. And then I had that table, and then I had all of the Rule 36 cases in the same relevant time period. And I started tracking them back and forth until I found out how many Rule 36 cases that the court had issued since Alice were on 101. But you can't get the statistic electronically. The court doesn't keep it. Nobody knows. So greater than 50% of the 101s are being decided on Rule 36. And think about this. This is coming up on Rule 12 on summary judgment. How can you do this? There's no facts, and yet the Federal Circuit isn't giving anyone in the industry the guidance they need to understand how to survive these cases.
And I think to Meredith's point that, there was a comment in one of the concurrences in one of the recent decisions where the court stressed, I think it was the Berkheimer en banc decision actually, where it stressed that courts should be reviewing 101 issues through the eyes of the ordinarily skilled artisan and not the ordinarily skilled judicial officer. But when you don't have any kind of factual record, you don't have any expert input, it's a good point, but it's very hard to implement in reality.
But I think that would be a good place to talk about this. I mean, how much sense does it make? Because there are two sides to this coin. When you file a Rule 12 on a 101, I've talked to lawyers who say, well, there is no factual, if there are no facts in dispute, you can decide that thing. And how much sense does that make? And I'd like to hear what some of the other experiences have been. We can go through the process for those who haven't done this. If you pull up 101, pull up section 12, Rule 12. Let's see, it's slide 8. So we put this up here just to remind everybody. Let's do slide 7, Rule 12B. This is what the rule says. A 12B motion is filed after the complaint. Okay, what do the people who drafted Federal Rule 12, what do they have in mind should be the result of a grant of a Rule 12 motion? The case should be dismissed. There's nothing in there that would say you should invalidate a patent on Rule 12B because you've had no affirmative defenses, you've had no counterclaims, there's not even been an answer. So if there's no affirmative defense or counterclaim, there's no reply filed by the patentee to allow the patentee to put in the facts that he might need. He's really had no opportunity. And So I really believe 12B is not an appropriate tool to invalidate a patent. And I don't know how you get from dismissed to patent invalid.
And I agree, and I think just from a procedural standpoint, under a Rule 12 motion, the court is obligated to take all the facts pled in the complaint as true. Every patentee pleads, I have a patent duly issued by the Patent Office enjoying a presumption of validity. And in the post-Alice Mayo world, lots of plaintiffs load up during prosecution. These things were vetted. This prior art was considered. This patent was considered not obvious and novel. And sometimes there's even been 101 rejections. You put all that in your complaint. It's the antithesis of giving all the benefit of the doubt to the patentee, the plaintiff, by saying, oh, well, forget all of that. As a matter of law, I say it's invalid. Case dismissed.
And to me, logically, how do you get from the presumption of validity that you have to a presumption of invalidity under 101 with no facts? How do you get from here to there? And that's what we're doing. So, I would like to see some sort of attack on the use of 12B for these types of motions. I don't know that it would be successful because I think the Federal Circuit is so ingrained in thinking these are okay that they don't even see these problems.
And I think they tried to deal with it in Berkheimer and Atrix in particular, because that was a Rule 12 motion. And, and I think the court felt like when the plaintiff patentee had alleged facts in its complaint. And so I think that drove the decision in Atrix. But then they've seemed to kind of run away from that a little bit. They recognize you have no choice but to give the benefit of the doubt to the plaintiff. But I think in reality, that's not happening.
No, and I think we were all, as everybody was probably very excited to see Berkheimer and to see Atrix. But in practice, it's still not being applied. And you see it in these Rule 36 affirmances. You go back and look at the briefs and you think, how did you get to this? And I believe the Federal Circuit is derelict in its duties. What is the Federal Circuit supposed to do? What are their duties? Well, they're a court of review. So they're supposed to review the case and make sure no errors have been made. And I don't think they're doing that. They're supposed to interpret the Supreme Court decisions, and they're not doing that. I agree with Professor Nard. All they need to do is sit and bank and make these determinations and kill this process. And for some reason, they seem to be afraid to do it. And I don't understand why, because I think that's part of their duty. And then, of course, they are the court of patent law. So under the Constitution, I think they have a duty to make sure that that clause of the Constitution is being upheld, and it's not. I wish the Federal Circuit would fix it. I think that's the best place to go. But I just feel like they don't seem to be taking the time. And maybe it's because they think that their docket is overwhelmed with PTAB cases, or who knows what it is. But I don't see the care and reflection in their decisions that I saw 20 years ago.
And I do think that point about the PTAB and those decisions overwhelming the Federal Circuit, I think that's a fair thing for them to be concerned about, because I think that change and those cases, they're hugely detailed, they're highly technical, and they do present a huge burden on the court.
Absolutely. But I'd like to hear, if anyone's dealt with this from a Rule 12, or is there someone who thinks the opposite? Like, is Rule 12 an appropriate vehicle to take care of these 101 issues? I'd like to hear about that, because I think I've gotten so ensconced in my position that it'd be good to hear the other side again.
Well, I think I will play devil's advocate. I actually do totally agree with you. But, from a firm that represents lots and lots of defendants, I think that from the defendant's standpoint, particularly if you're being attacked by a non-practicing entity, those defendants welcomed this procedural mechanism to cut off and take away the really heavy economic leverage that a plaintiff can wield against a defendant, because to get to summary judgment is hugely expensive. And, and when you have a non-practicing entity that they have no burden on the discovery side, they might have a file folder or two. They produce the file history and then they say, well, we don't do anything, so this is our full discovery. But we'd like you, please, to go through many terabytes of data. We'd like you to review about 6 million emails. We'd like you to sit for about 10 or 15 depositions. We think the rules should not apply to you because you're a big entity and this product line is huge. And we'll talk about, so you can spend, $5 million to get to summary judgment, or you can pay us the very reasonable fee of $500,000 and we can all go home today. And when you're a defendant facing those choices and not having any real exit, maybe you've got a Rule 12 personal jurisdiction argument, but barring those kind of things, you're going to be in for the long haul. And so these shakedown moves, if I can be a little disrespectful to the non-practicing entities, are really a problem. And so I think that's in part what's driving
I agree.
the courts to want to give an escape route. I think they're doing it in the wrong way. I don't agree with it, but I do think that from the defense side, maybe that's the other part of the equation that folks need to be thinking about as they're trying to fix this problem is, how can we protect defendants from unfortunate lawsuits?
And isn't that part of what the AIA was designed to do?
Sorry, Jeremy. So this is really fascinating to me. On the Rule 12, we mentioned the person having ordinary skill in the art. One of the things I think is woefully inadequate to any case in patent law is the insufficient time spent on how the type of ethical person is constructed, given that this is the rock star of patent law. Everything is viewed through this person's lens, but we don't spend a lot of time on what is ordinary art. But it's richly factual. So in that context, we could engage in claim interpretation, and Teva tells us that there are factual components to that. You need to construct your codiga, factual components there. Before you do any of that, how can you get rid of it? Now, I understand why 101 is a great vehicle compared to 102 and 103, but you can say, that's the law of nature. I don't need to consider any prior. The law of nature, let me get into step 2 here. Before Berkheimer, you say, I could determine if it's well understood or routine as well and can get rid of it. So Berkheimer is really, I think, a step in the right direction as well. But I think there are other ways to do it. I think lawyers, you drive the train in terms of getting forward to the investigation you want them to address. You just hammered, we need to construct a person having ordinary skill in the art. You have to do that. Judge, you mentioned you're smart, but you majored in terms of whether you don't have the PhD in bioethics. That strikes me as a strategy for these lawyers.
And I think that's when you're seeing Berkheimer and Atrix, I think you're seeing the results of counsel coming in and loading up the complaint and dealing with the prosecution. It's almost like you're filing your answer to counterclaims with your pleadings. But I like the idea of dealing with the person of ordinary skill in the art as well. I think it's going to be hard to get people to focus on it because usually it's just brushed aside as a person with however many years of experience.
Would you find it helpful for the prosecuting practitioner to include a statement or argument in response saying, you have not defined what procedure is, how can I understand what you're arguing? And then they inevitably ignore that. Now you have the record that was never established. If you were to make this argument later on.
A lot of times it's not established in the prosecution history. And so we end up making this argument, at the PTAB for the first time, really. And the PTAB seems a lot more inclined to address it on the merits and think about it. And I've seen really great PTAB, not in 101, but PTAB discussions where they're looking at the different experts and they're saying, well, this expert isn't one of skill in the art, but this expert, and I think that I think you'll see more of that, but I don't even really see it defined in the prosecution history all that often.
Right, it almost never is.
Yeah.
When you do present it, you never ignore that.
And from a litigation perspective, I'm not sure I want it defined in the prosecution history because I may have reasons why I want it to be different from what we may have wanted it during prosecution.
I think that's exactly right. And I think, to your point, Professor Nard, when you're the plaintiff and you're still at the pleading stage and you don't have any discovery from the defendant, it's uncomfortable to stake out concretely your claim constructions and your level of ordinary skill in the art. And in the orderly course of litigation, you get some discovery, you get some disclosure, you depose maybe, the defendant deposes the inventors, you hear what your folks are going to say under oath, real clearly, and then you have a big picture and a full record to make those claim construction arguments, to identify what the person of ordinary skill in the art is, and not handcuffed by something in the prosecution history, for example. And I think this just circles back to why it's so dangerous to decide 101 on a Rule 12 motion, because none of that has had a chance to happen. And the way the Federal Circuit has dealt with that, when a plaintiff patentee wants to play it a little careful and not stake out a position, then they immediately say, well, the patentee didn't propose any claim construction, so we don't have to deal with that either. Move right on to throwing the patent out. And so it's a very uncomfortable position for the patentee to be in at that point in the litigation.
What I agree completely, and if you think about it from a process perspective, if you're the patentee, you don't know when you file the complaint which limitations they're going to dispute. And so it's really hard for you. If you can have a claim construction, but you don't know if you need an underlying expert then, and you don't know which ones are going to really, you kind of do, but you kind of don't, which ones are going to be an issue. So it really puts the cart before the horse to require the patentee to do all this in the complaint. And so we put up the slide on underlying facts in patent eligibility. On a motion to dismiss, you can't have anything outside the pleadings, as we've discussed. But, and I think now patentees are starting to add, file history, relevancy, and we're really starting to see some of these patents coming out that have been examined post-Alice under 101, and that's helpful. So some of these we can remedy, but it's really hard, I think, to put a claim construction in there. I put the last bullet point in because as I was reading cases, I was appalled at, you can't consider anything that's not in the pleadings, but the judge, and I'm sure from the brief of defendants, the judge is saying, well, this electronic database is really nothing different from a library filing system, and therefore it's not patent eligible. That's not in the pleadings. How'd you get that analogy? How are you able to do that without sticking to the bare pleadings? Or the best one is, this was another database. This was another database. He said, well, that's just like a barista serving coffee to his regular customers by memory. Huh? How is that? How can you make that analogy? And it's just so frustrating. My favorite one at the bottom is Judge Moore, and she said this at oral argument about an AI patent, and the AI patent was directed to on your mobile device, like when you end up in a different city, like you land on a plane and you turn on your mobile device and it had learned what you like it knows that you like to eat dinner at a certain French restaurant or French food, and it pops up and it says, hey, I see you're in Cleveland and they have these great restaurants that you might want to try, or something like that. And Judge Moore said, well, that's like when I clean up my kids' toys and I put them in the toy box, and maybe they like the dinosaur toy better and I just stick a red sticker on it so we know. What? How do you make that comparison? So I am angry because I feel like we're getting hit on both sides with this.
I think now maybe we can move forward and look at some of the cases we have listed up there, and just briefly go through them and maybe try and see what trend we're working towards right now and where we could see the immediate development for 101.
So I think we could skip Berkheimer and Atrix. I mean, we've talked about those enough, but those are the bright and shining lights in this jurisprudence. Looking at other recent ones, I put this Ancora case in here because I thought it finally recognized the problem, one of the problems. So here's a case, it's a software, and it had survived re-examination, and it had survived a prior appeal on claim construction and on indefiniteness. And yet the district court dismisses on the pleadings as not patent eligible. How do you do that? And it had been, many of these cases, the Federal Circuit just rubber stamped it. But here I was actually encouraged to see the Federal Circuit saying, no, this patent survives. So I don't think this is a very noteworthy case other than it's showing that the court may be now recognizing that, and it may be that all this stuff was put into the complaint, right? Wouldn't you? I would.
So the natural alternatives case, this was argued, I believe, the Monday before the Cleveland Clinic case. And, it's similar kind of things. You've got method claims and this natural product. And the court said this one's ineligible. I'm sorry, I'm going to get this backwards. Reverse the 20. Yeah, so they said it's eligible potentially, and we're going to reverse it. And they failed to demonstrate that under the claim construction that the claims were not patent eligible. So I think, again, that's a nice step towards where we would like things to go. But I think the point of flagging, we've got Judge Reyna's dissent, and he really has staked out his position in the court as this is a question of law. He really thinks that things should be weeded out at the 101 stage. And he's very, feels so strongly about his position that I think it impacts his finding on these cases and pushes him towards the finding things ineligible and maybe sometimes ignoring some important facts because he feels that he doesn't want to, and he's even so much as said in some of his decisions that he doesn't want to be a fact-finding exercise. He just wants to look at it on the cold record and make a decision. So I think his dissent is very significant. I think it's the fact that the two judges on the panel moved towards where we'd like to be from a pro-plaintiff standpoint. His dissent shows a couple of things. Certainly his very strong view on the other side, but also just the dissension within the court. And it's seen in a number of cases. And it doesn't look to me like they're getting any too far along and coming to any kind of a majority alignment. They're still all over the board.
One minute, and then I'll get you. If you look at this sentence, so Judge Reyna dissents because he thinks the claim construction is wrong. But this is a Rule 12, so aren't we supposed to take everything in the non-movement's favor? And I guess that all goes back to Judge Reyna says claim construction is a pure question of law. And so he can say the claim construction is wrong. So to me, there are procedural tensions here that need to be worked out and haven't been.
When you look at the inconsistency in the cases, I mean, you touched on it a little bit, but how much of the inconsistency in 101 do you think is attributable to just the individual Federal Circuit judges having just very distinct philosophical approaches to what should and shouldn't be eligible? I mean, is there even any hope for an en banc case where they could come up with some guidance that applies across?
What are you thinking? They're going to issue another Alice? It's bad. It's bad. It's totally panel dependent. If you end up with Judge Moore right now, you're in good shape. Judge Chen usually, the double E judges, now that you think about it, Moore, Chen, Stoll, you have a good fighting chance. But if you end up with some of the non-technical background judges, you're in trouble.
So I'll jump ahead a little bit because the Cleveland Clinic case was decided April 1st. And to your point, we drew Judge Moore and we thought this is the best thing ever because after Berkheimer and Atrix, and we'll talk about the details of why that was very important, the Berkheimer and Atrix decision for that particular appeal. But we thought, and then we had the other two judges were on the creative case, and they had made a big issue about deference to the PTO on the Monday argument before we argued our case on Thursday. And we thought, we've got the dream panel. We've got the Berkheimer judge and the PTO deference judges, and it should be just the best outcome ever. And when we got into oral argument, within the first 30 seconds, one of my colleagues described it as bizarro world, because Judge Moore kept asking us these questions about how she thought that everything we had said was completely wrong, and she completely didn't agree, and she had no discussion of fact issues. And even our PTO deference judges, they were hammering the other side with questions about deference. And then the way the case came out, they said they're just going to decide it along the same lines as the first clinic case, and they dismissed pretty much out of hand the factual issues, and they also then said they weren't going to give deference to the guidelines, and in fact found one of them completely invalid in light of Ariosa. So, I think, yes, it's completely panel dependent. I think the reason this law is messed up is because the judges have a variety of opinions, and they're each making decisions that are tainted very heavily based on their personal views of the law, and then they don't stick to them, in my view, consistently in all the cases. So you've got the dissent among the ranks, and then the judges are flip-flopping around a little bit too.
Okay, really quickly, I would like to just get to the Hickman v. Vanda case. I think in conjunction with Berkheimer and the Supreme Court's interest, I think it would be maybe helpful to get the full picture here.
Okay. So Vanda is interesting because, in Vanda, and I think everybody is appropriately praising Vanda for being a big step in the right direction. And then, because here you've got them saying when you add that method of treatment aspect to the claims, that transforms it into patent eligible subject matter. So I think, for our inventors who are able to tack on that additional limitation, I think this is great news. When I think about it sort of theoretically, though, the idea that, that a claim that's perhaps diagnostic in nature, if you say, and therefore treat it with X, it converts ineligible subject matter to eligible subject matter just by virtue of tacking that on. Fundamentally, isn't every diagnostic method, the point of it is to figure out how to treat the patient? So to me, that is a distinction that, yes, practitioners should latch onto and run with as far as it'll take you. But it seems to me that from a theoretical standpoint, it's silly, that we're going to say, if you just claim in the abstract this diagnostic method, we're going to say it's all based on some natural correlation in the body, and unless you come up with some miraculous new way of detecting that correlation, and you can prove it's innovative with no factual record, so you can survive your Rule 12 motion, then it's going to be an eligible subject matter. And I don't think that's intellectually honest, in my opinion.
And it reminds me of, for those of us in the software world, do you remember Beauregard claims, right, in a computer readable medium? It reminds me of that. If you just stick it in the computer readable medium, we're good to go. And it reminds me of post-processing. It's just interesting that it's almost like we're coming full circle, and the advancements we've made somehow, I hope they're not being lost, and I hope we part through this fog quickly. Now, Vanda, along with Berkheimer, they're both up at the Supreme Court on petition for cert. And the court has asked for the comments of the Solicitor General on both of these, and we're waiting. We're waiting on that. I know, what do we want to have? Obviously, we know what we want. What do you think is going to happen? I don't know. I would hope the Solicitor General understands civil procedure well enough to be able to weigh in on that, but I feel like they're going to weigh in on the technologies rather than the civil procedure aspects.
I think there's definitely some danger of that. I think also, the Solicitor General is going to be representing the patent office and as its client, at some level, because it's representing the government. And it'll be interesting to see, to the extent that the PTO feels like Vanda is a helpful decision, and Berkheimer and Atrix, and they want to keep those tools in their box for examining patents, I think you're going to see the Solicitor General recommend that the court not take the case and just leave it alone, but who knows?
That would be terrific. That would be an excellent result.
Are you concerned with the fact that Vanda really goes against what the court said in Mayo, that this should not be a claim drafting exercise? And while Vanda has been an excellent step forward for us, my concern is that if the Supreme Court does grant cert on this case, that they're basically just going to use it as a tool to reaffirm Vanda's incorrect and we need to be following Mayo and Alice, and we shouldn't just be wrapped around this issue. So you have insights on that, or?
I think it's a fair concern. And I think, we've seen cases where the courts have said, that some claims are drafted one way, and when a patentee has gone back and gotten additional claims and reworked them to try to conform with whether it's Vanda or whether some of the other precedents, and to say, okay, we understand that that wasn't eligible subject matter, but if we reframe it this way, maybe it is. And then those courts have said, sort of akin to the moving the deck chairs on the Titanic, that we're not going to accept that. So I think that is a valid concern, and that's the thing about Vanda that sort of strikes me, is that we're not looking to the substance. We've just added this little superficial fix.
And I think you've hit right on it, Rebecca. When you talk to most of the practitioners, when I have in the life sciences area, that's exactly what they're afraid of. And I think what you've described, isn't that what happened in the Cleveland Clinic series of cases?
It's exactly what happened there.
And I felt like as an outsider looking into the life sciences area, I felt like the court just did a punt on the second Cleveland Clinic and went, well, this is like the first one, so we're done, rather than really take the issue on head on like it could have.
Yeah, I think that's exactly right. And I think to get to that result, they ignored some really important factual issues, and the biggest one, in my mind, is the district court in the second Cleveland Clinic case. When the motion to dismiss was brought from the bench, the judge said, I'm looking at this, and she says, I have to tell you, I've never invalidated a patent on the pleadings. I'm very troubled by the notion that a patent could be invalidated on the pleadings. I think that I know under the 101 test, I need to look at innovation, and I really think I need to hear from experts to understand what a person of ordinarily skilled art would understand about that. And she didn't have the benefit of Berkheimer and Atrix. They were decided after the case was decided. And so, but she could not have more clearly aligned with Berkheimer and Atrix in her comments from the bench. And then the Federal Circuit decided the first Cleveland Clinic case, and the other side moved to reconsider. They said, in light of this, we feel like you really need to reconsider your decision. And she said, well, I had some concerns about factual issues, but I see what the Federal Circuit has done here, and I feel like I'm compelled now to dismiss the second case. And so the second part of that is what made it very different from the first Cleveland Clinic case, is that the continuation claims were drafted in accordance with the PTO guidelines. They went through 101 analysis. The patent office found that that they were exactly tracking with example 29 of the guidelines, and that under their rules, this was not even claiming ineligible subject matter. There was no 101 issue, period, because the claims were rewritten to say, we're going to claim this new and innovative laboratory method for detecting MPO in blood in patients that have cardiovascular disease. It's an innovative use of a thing called an ELISA in order to detect MPO in blood, and we were just claiming the lab method for this new and innovative purpose. And the judge said, I just don't think that's a distinction. And the Federal Circuit, in affirming the district court, said that the distinction in the claims, to your point, were, quote, overly superficial. So, so I think that's one of the big problems. The Federal Circuit also failed to acknowledge that a sitting district court judge acknowledged on the record a myriad of factual issues that should have invoked Berkheimer and Atrix. And they just dismissed that under the rug. Now, there are some statements in the specification that, taken out of context, that the court found were dispositive on that issue. And that's also unfortunate because this was a pre-Mayo spec that had carried through into a post-Mayo world. But they didn't have the benefit of the record. Had the case proceeded and the inventors had been given an opportunity to explain that what they did, that the ELISA test they did was not conventional and ordinary, but in fact was very tailored for this purpose. The other point, so I don't prattle on too long, to point out is the prior art was very interesting. So the alleged natural law that the court latched on in the first Cleveland Clinic case and then relied on again in the second was the alleged correlation that high levels of this particular enzyme, myeloperoxidase, or MPO, high levels of MPO correlate with a risk of heart disease. That's their alleged natural law. But in the prior art, they had done various tests for MPO using, our own inventors did a test using a test called MPXI, where they were looking at MPO in the blood, but in a little different, using a different technique. They spent 5 years. They graphed it all out and found zero correlation to MPO levels determined by MPXI and the risk of heart disease. So they said, well, this MPXI method is not going to get us where we need to be. So they started with ELISAs, and when they did the same test using an ELISA, that's when they found the correlation. There were also at least 2 other references of prior art, one involving heart bypass patients who plainly had coronary cardiovascular disease, and using the blood assay that author used to detect MPO, those patients had low levels of MPO. So our point to the Federal Circuit is your alleged natural law is not a natural law at all because it's completely method dependent. High MPO detected by a particular method does indicate risk of cardiovascular disease. But and that was our discovery. And the court completely ignored all of that evidence. And some of that was in the file histories, which, by the way, were attached to the complaint, so completely appropriate material for the court to rely on a Rule 12 motion. And yet here we are.
I think we've identified 2 problems in the Federal Circuit. One is the panel dependencies and the very stark views of many judges, which they seem to not believe need to follow precedent. And then we have the inability of the Federal Circuit, at least until Berkheimer Atrix, to instruct the district court on how to apply the basic civil procedure rules. It's very frustrating. We have up here just statistics, which these are indirect indicators of harm, I think, in the industry. But if you look at, this is just the number of patent accusations by technology. And you can see the big blue line, of course, is tech cases. And you can see that big peak up at 22,000. That would be where the pleadings rules were about to change, right? And so everybody filed their case like the night before the pleadings rules changed. So that's kind of an artificial peak, I believe. But then you can see what's happened, since Alice, and it's not a good thing when you're not able to enforce your patent. Combine 101 with a 101 pleadings dismissal with a PTAB action that you're almost malpractice if you don't figure out how to file one of those, and you're spending probably close to $500 to $1 million just to get to square one and assert your patent. And I think that has a bad effect on technology and, of course, on the economy and everything we could talk about, from an economic perspective.
Okay, so I had some questions planned, but I think maybe we should just open it up to everyone.
So do you have any recommendations for how you would move forward in trying to solve one of these 2 problems?
Yes.
Well, I think we've talked a little bit about that, and all of them have their pros and cons. Certainly Congress has the power to enact statutes that could remedy the problem, but concerns about whether or not they are properly equipped and, could even get the job done, let alone, what the result might be, given all the cooks in the kitchen. I think that's, and cooks that maybe don't fully appreciate all the practical ramifications of what they're doing. So I think that's an issue. The Supreme Court could certainly come in and say we made a mistake in Mayo, or we want to clarify Mayo, or, this has gone really off the rails since Mayo. But I don't see that happening. I think their opportunity to do that was when the cert petition in Ariosa was brought, and they declined to do it. And so I think that is a pretty significant indicator that they're not really 100% sure what to do. I think we've talked about the Federal Circuit has the potential ability to, with an en banc decision, but getting them to align and to come to some kind of consensus, I think would be very difficult given the current state of how they all feel about the issue.
It's not a solution, but I do think if you look at the recent appointees to the court, that's where some of the most positive decisions are coming from. I don't know why. I don't know why some of the stalwarts on the court can't issue these same decisions. But you look at Chen and Moore and Stoll, and I don't know. I'm just hopeful that maybe we can continue to populate the court with good people, and that's a very long-term, not solution, but hopeful solution as well.
Well, I think that's right. And I think in building on your point, I think some of the more long-term members of the court, and you see in their decisions, they really feel handcuffed, and where I think they feel really bound by stare decisis, and they feel really bound. You have Judge Newman saying, I think that Mayo and some of the later cases were wrongly decided, and I think the Supremes need to take this up and look at it, but I feel handcuffed. Judge Lurie said many times, I totally don't agree with what we're doing here, but I feel like I have to do it. And, and I respect fundamentally their doctrine and their view and their commitment to not be a judicial activist, which I think, and I'm not saying that that's what these younger judges are doing, but at some level, for it to get fixed, yes, somebody's got to break out of the mold. And I think that fundamental divide in the court is also creating some problems.
It's interesting, because it is almost an old new issue, because Judge Michel is adamant that the Federal Circuit can't fix it. And to me, I don't see precedent as being a bar to fixing these problems. I see sloppy judicial work on the part of the Federal Circuit, the Supreme Court too, but I don't expect that much out of them. And because I just don't think they understand it. But I feel like the Federal Circuit, I don't see precedent as a bar, but I am missing something, because Judge Michel certainly does. And he thinks it's got to be done by Congress at this point.
I think you both touched on, including things in your plea to try to survive a motion to dismiss. Is there anything that you found that has been helpful to incorporate into the pleadings that might help remedy this situation, or do you think it's too far gone?
There's something I haven't done, or I've thought about it, but I haven't done it. Have you done it? I'm just putting an expert declaration in my pleadings, in the complaint.
I've seen it done, and it didn't help.
Oh.
I mean, that's what I think is the problem is, yes, put absolutely everything, including the kitchen sink, in your complaint. I mean, and an expert declaration can't hurt, except for if you survive a Rule 12 motion and then you find out that you just declared exactly the opposite of what your infringer's doing, and then you just killed your infringement case. But putting that little side part of it,
is why I haven't done it.
But yeah, I think you should absolutely put everything, because it helps, if the court's inclined to say, I think the defendants make a good point, you can say, well, at a minimum, what they've made is a factual dispute. And under Berkheimer and Atrix, this is completely inappropriate to resolve on Rule 12. But having said that, what I've seen is the courts say, we're not really required to take as true things that we don't think are true, and we could decide as a matter of law, done.
That's exactly right. And, I would think that it's just some education of the district judges about what a patent is, and yet there's no one to do that except the Federal Circuit, and they're not doing it.
And I think to the contrary, and we'll get to Robbie, to the Federal Circuit for a long time really actively encouraged district court judges to pour these things out on the pleadings. And I think they're regretting that at this point, or at least some of the court is, but the cat's out of the bag. They've already, that train is way down the track.
So as someone who worked at the Fed Circuit last semester, I think everything that you guys are saying is exactly true. I think that a lot of the judges do feel handcuffed. It's just too far gone at this point that the panel decisions, like, they don't feel like that they can move things at the panel level. And then it's a whole other burden to go on bond. And then you gotta get everybody aligned and things like that. So,
And then they're just going to get reversed by the Supreme Court anyway, so why do it?
Well, and I think from the litigant standpoint, and I don't fault the Federal Circuit for doing this, but when you get a decision from the Federal Circuit, you get directed to this little one-page fact sheet about rehearings en banc that explains to you in great detail how you can file one if you want, but your chances of anything happening is like slim to none, and slim just left. And it's, they explain to you that no published decision leaves the court without the entire court reviewing it first, and
Court. That's court in quotes.
yeah.
I'm not saying what that means, but that's court.
Exactly. And but I think they actively discourage rehearing petition. At least that's my read of this little fact sheet, and it goes out with every single decision.
And maybe it's worth saying when every chambers does things differently. The judge that I clerked for is no longer on the bench. I don't think that he did things in an unusual manner, but petitions for rehearing come in, and they're assigned to a law clerk to review and to find.
the intern.
And if the law clerk doesn't spot the issue or doesn't see the value, and this is, like, I had 4 years of experience when I clerked, so I felt like I was a really senior looking dude. I knew patent law, but think about it. It's really hard for a young person, even 4 years, to know, and you're tired, by the way. You're tired and you're like, oh my God, I got to read another one of these yellow things, and all they're going to do is complain about the decision that I spent forever drafting. So there's a bias of getting any of these things looked at the beginning. And so for an intern too, I mean, you're an intern. Are you going to go to the judge who just wrote this decision and say, you made a mistake?
Well, you're exactly right, because if something came by that I spotted, right, I mean, I don't have as much experience as the clerks or anybody else there, but then I have to then make the case to the clerk, and then they have to buy into it enough that they want to make the case to that judge, and then that judge has to buy into it and say, oh yeah, this is a really important thing, and then they have to go to 6 other judges.
The panel first, and then the rest of the court.
Correct. To try to get the decision heard on bond, get everybody to buy in. But if they weren't on the panel doesn't want to hear it on bond because they had already decided. So it is a monumental uphill battle.
And it's all done on a clock, right? There's it's either 7 or 10 business days. So you file your petition for rehearing. It goes to the panel for 7 or 10 business days. I think it used to be 7. They may have increased it to 10. Anyway, it's a clock. And if the panel does nothing, then it moves to the full court for that same amount of time. And if the full court does nothing, the mandate issues. That's that. It's done. And so there's so much ability for, I think, meritorious issues, unless there's a judge, and I've seen this too, unless there's a judge saying to his law clerks, watch these 101 decisions and find me one. That would be the way that you would spot these. But otherwise, until that gets to a point where the judges want to take one in bank, these in bank petitions are going to probably fail.
You mentioned in the Cleveland Clinic case that there were some statements and specification that were problematic. So I just kind of wanted to introduce the question of what can be done at the patent drafting stage to avoid getting into these situations.
So we may talk about that next, I think.
Yeah, I think that's our next panel. We'll talk about that in detail. And I'm just going to say, from a litigation perspective, we hope our patent drafters are sort of omniscient and know what's going to happen in the future and what the future infringers are going to do. And it's really easy to second guess after the fact. And so I don't want to make it seem like that. And I think that when, in our case, the issue was trying to put in some language to make sure that it was clear that a person of ordinary skill in the art would understand these techniques and that they were fully enabled and all, that those are the kind of statements that in a post-Alice world can be twisted into say, well, maybe there was no inventive step, that this was just all routine and conventional. And so, it's sort of by hindsight unfortunate, not that I'm saying that it was unfortunate drafting in the first instance.
I guess I'd say I gave a talk at Cephalus some years ago. Don't put any of those admissions as to the level of ordinary skill in the art, because the application can only be getting asked to.
Yeah, I think that's fair.
As a litigator, again, I recognize no patent is perfect. You can't. There's no way. And it's such a complex document. And what I like to see is in the technical areas, which of course sometimes are very skinny on the spec, I want to see a developed spec. I want to see multiple embodiments. I want to see as much structure as you think you can get in there and more than one flow chart, please. And, but I realize if they're drafting on a limited budget, you can't do that. And oh, by the way, maybe you've got like a young patent agent doing it because the partner can't spend that much time on it. And we all know we've got that problem and that give and take.
Or a law clerk.
Well, and I think the other problem is you're at the drafting stage, you're trying to claim this invention as broadly as you can to give your client the broadest protection. And, and while you claim broadly, if your spec is describing certain formulas or things in a lot of detail, which later might be really helpful to show how this was really an innovative and new and creative thing, the spec, you're drafting them perhaps broadly so you don't get some overly narrow claim construction later that takes that broad claim language and tries to narrow it in because, well, the spec only talks about this one really highly specialized version of the formula or something. So I think there's a real tension there with trying to be as broad and try to cover all future eventualities, but then the one that actually does come down the pike is the one that can sometimes get caught up in some language that's there. It's really difficult. Yeah, Rich?
So it's interesting. I was thinking about what Professor Nard was saying about we always just cringe when the Supreme Court takes cases, and they haven't given us a good verdict in a long time. So we all don't really want them to take the Vandy case. But if they don't, then we're just in this situation where the patent office guidelines say write the cases, we can issue the patents, but they're not going to make it through litigation. So we're in this sort of no-win scenario unless somehow they take the case and end up with a verdict that they want.
Right. No, I think that's right. It's
That's a shitty dice roll.
Well, it is, and Meredith has exactly the slide on with the quote. So Judge Michel, when he testified in 2017 in front of Congress, he said, "The law has created unacceptable chaos for inventors, innovators, business, and investors. Legal chaos is the exact opposite of what our economy needs." And to your exact point, you don't know, and it's that uncertainty that really is the problem.
As you know, I work in a space where I'm trying to advise clients to go ahead and protect it because we're going to license it or we're going to sell it. So, what's the value? Now, how enforceable are these claims? And is somebody going to take it on with this big cloud sitting over them saying, who knows what's going to happen if you try and go to court with this?
Oh, you're exactly right. And in that respect, your own licensee almost becomes the adversary. So you've got to be thinking about these things not only by how you're going to stop the infringers in the marketplace, but then how are you going to make your licensee keep paying you because they're not convinced the patents are enforceable either.
So that's where it starts to really impact.
Yeah. Yeah, I think it's a really big issue.
There's a problem in the tech side of that with, a lot of tech patents are at the beginning of a company, the company's trying to get going and they're not able to get any funding anymore because why would you invest in something that has less than a 20% chance of ever being worth it?
I think we got 2 questions over there.
I mean, I think along those lines, and fear of the Supreme Court, I too am afraid of what the Supreme Court would do, especially on the abstract idea concept. They've tried not to deal with it, and the things that they've said, I think there's a lot of issues there. But at some point, because of this chaos, I would almost prefer, tell us something explicit. Let us stop this back and forth between a new company, especially in the software space, having to literally decide whether they invest in a patent system that may not ultimately benefit, to the detriment of them spending R&D and commercialization trying to get out in front of the market. Right now, they're having to do those both, and it's very difficult. I would almost rather, if the ultimate decision is going to be that this stuff isn't eligible, then just tell us so that we can advise the client. But to keep it in this legal limbo where, I don't know, your only solution as a player in this industry is to throw money at the problem because now you've got to go down both paths, that's not sustainable. I'd rather at some point just rip off the Band-Aid, tell us what the situation is so that we can start to work within that environment as opposed to, I don't know, that's not an answer.
That's exactly right.
But to reclaim new jobs for those double attorneys.
At least you know what you're going to do.
I always said ambiguity is my students what's on the exam. Ambiguity is your friend. You didn't have ambiguity when you were a child. but there's something to be said. At Michelle's point, a bad decision that leads to certainty is better than harmful ambiguity. To Rich's point on licensing, is it true to the front cross folks that when you draft your spec with enablement in mind, you want to pass the legal threshold to satisfy enablement and no more? What that means is that when you license, the licensee knows that there's a whole bunch more information that's not in the spec. It's not that you say, here's the patent, collect royalty. There's know-how, there's passive knowledge, there's access to the invention. So it seems that you could satisfy enablement under the value that's hidden in that patent doc that the licensee is going to want. And so then the licensee could still say, look, I'll pay this royalty even though I can have a sort of a plausible challenge of the validity because I don't access to the Cleveland Clinic PI as well as all that data that's not in here, and you negotiate over the royalty. So in other words, 112 only requires so much. Your value could be what's not disclosed. What is not disclosed, you can negotiate over that. Is that an accurate statement? Or is that
I'm only going to give you one perspective. I think it's accurate. The tough part is that everybody wants that tangible amount of IP. So, you see today licensing patent applications before they've been examined much tougher. Licensing examinations after they've been examined better. Licensing patents after they've been issued even better because they want to know what are the means and bounds of protection. And of course, they understand that access to PI and that sort of thing is a good thing. But anytime you take it out of that less concrete and tangible zone and back into that know-how arena, the numbers, the value of the deal starts going down.
So it erodes that. You need that starting that's narrow.
And I think the other part of that too is without patent protection, then what the licensee is getting is not exclusive. Now maybe he's not getting exclusive license anyway, but if you're negotiating for some kind of exclusivity, no minimizing the value of all that insider information. But if the competitor down the street can do it too because the patents aren't valid, then why should I pay extra for the privilege of doing the same thing that the guy down the street can do without the royalty burden? So
you bring in a lot of other considerations, fair market value. On the orthopedic side, the DOJ got really involved with a lot of their deals because they had all these sort of fuzzy numbers being shifted around based on know-how.
Mm-hmm.
Maybe some other activities, but that gets tough for sure.
Yeah.
How is this affecting foreign patents? And might there be foreign pressure to actually fix this?
The European system has a much better patent eligibility, much more certain than we do right now. And China actually changed its laws recently to make it more accessible in the software arena for patent eligibility. So at least from the government perspective, like China has recognized that we're going to get this business because the U.S. is stumbling. From a foreign business perspective, I don't have a feel for that.
Yeah, I don't have anything more to add to that.
Going back to more of the district court litigation, what are your thoughts on things like the patent pilot program and doing more specialization at the district court level? Do you think that's a good idea and that might help alleviate some of the issues we're seeing at the district court level?
I actually think that, it's great to have a judge who's technically savvy in a patent case versus the one who picks up the complaint and says, oh my God, another patent case, I hate math. So I think that's a good thing, but I do think in this particular area where we really don't want judges making decisions on the pleadings, that a technically savvy judge might feel more confident and actually might get into more trouble under 101 and not defer or decide he needs or wants more of a developed record. So I think that could potentially be problematic.
I think the patent pilot program, at least where I spent most of my career practicing in Chicago, it was vibrant, and the judges came to the bar associations and the judges participated, not all of them, but I guess 5 or 6 judges were very active. And for us to be able to have that one-on-one dialogue with them, or for them to be able to sit here and listen to these 101 instead of one-on-one, 101 problems, I think it's very helpful. And, even though I don't live in Chicago all the time now, if I can file a case in Chicago, it's not the fastest court. It takes 2.5 years to get to trial. I would go to Chicago before I'd go almost anywhere else because I know these judges, because I know them. I know they are at least somewhat attuned to what's going on in patent law, and I know the type of diligence that they put into their cases. So I guess one way to address this problem too is to, find that way to have a dialogue with the judicial community in the area in which you sit. And you can only do it if they're willing, right? But the patent pilot program judges seem to be, more willing.
I think we're going to have time for maybe just one more question, so.
So I was just going to ask you a question, and I was going to respond to the international question as well. So I'll do that first. So under the NAFTA, Lilly challenged in Canada on the promise doctrine, right? And that's because of the provisions of the NAFTA to allow sort of that difference in laws between countries. And under the Trans-Pacific Partnership, when that was close to being finalized, it also had language in there about potentially giving a country an opportunity to challenge another country on their laws. If the TPP had gone into place, maybe we would have seen something in the 101 space because, again, the U.S. has shifted away from Europe, as you mentioned, and some of the other countries. It's not there, but that would have been sort of an interesting development to see because we're at such a different place now than many countries on that. So that's something that never came about. I'm just going to call it an ambiguity as well. So the Cleveland Clinic 2 decision, the point about challenging the example that PTO puts out, that is wrong. We need to do that. We need to continue to find the right balance. But what troubled me today was hearing Sue talk about sort of the facts that sounded like they were the right facts. Maybe it was because it was still a pre-Alice, pre-Mayo spec that really did it in. But, I mean, what are we to do if not challenge the ambiguity with the right facts? How do we develop that? I mean, we've heard you talk all about the courts and sort of where they are, but like, aren't we still supposed to, as attorneys, find the right cases with the right facts and push them forward? But where's our hope that it's going to be actually seen and not dismissed on the paper?
I think that with many judges, they're going to get dismissed on the pleadings, and I feel like it's a question of, to your point, just keep chipping away, keep being the advocates that we need to be, and keep pressing the issues to the best of our abilities. I think sometimes our clients lose hope, and they're the ones that, at the end of the day, have to finance and keep these issues moving forward. And so I think that's an issue and a concern. I feel like in the law, there's a pendulum, and the fastest pendulum swing I ever saw, and that I think ended up right, was the patent marking issue. You may recall, patent marking statute had an ambiguity in it. There were all of these key TAM suits. Hundreds of them got filed in a very short period of time because of the Federal Circuit's decision to say that you could share in the profits. And it wasn't just one instance of false marking, it was on every item. And so these folks were going through the grocery stores and getting every toothbrush with every expired patent number on it and saying, well, Procter & Gamble sold 9 billion toothbrushes and we'd like a penny a piece, thanks, for this false marking that injured us. And for about a year and a half, I worked on more than a dozen false marking cases, and our clients were getting just drugged through this ridiculous expense over something that up to that point wasn't even, for sure, even a violation of the statute. And Congress acted very quickly, and they legislated the false marking cause of action essentially out. And those cases went from being the hottest thing going to they all got dismissed, and it was, and the pendulum, the court thought it was doing the right thing. The immediate consequences were horrific, and Congress fixed it. And I think that that's how our system works, and I have hope that it ultimately will work, but we're sort of in a really difficult period of time where we don't know where the pendulum's going to end, and there's chaos, and it's unfortunate, and the clients and the inventors and the business people and the economy are all caught in the midst of this really whirlwind, and I think it'll sort itself out, but I think it's going to take a long time.
Okay, well, thank you very much for being here today. We're going to do a break, 15-minute break, and have the second panel set up.
I was going to say what you can do is get active.